Please the court. My name is H. Lewis Sirkin. I'm from Cincinnati, Ohio, and I'm proud to be here before the court. Your Honor, what I'd like to do to begin with is to tell what this court is not about, this case is not about. This case is not about sex trafficking. It is not about the use of minors in any type of way for sexually explicit material or for sexual acts. This is about adults and consenting adults who voluntarily want to engage in an occupation that would be sex for hire. And we believe that under the principles that were announced in Lawrence versus Texas, that such right has been granted. An individual's right to make a choice in intimate sexual conduct is left by the liberty interest provided by the Constitution and substantive due process. It's a law that infringes upon the right of individuals to make their own individual choices of how they want to behave. It does. I think that the level of scrutiny in this case is, I believe it's a fundamental right, and I believe it was strict scrutiny, and let
me get to your question, your issue on fundamental right. What is the fundamental right? The sex conduct or the personal relationship which arises from the sex conduct?
I believe it is the conduct.
Then why do we have in Lawrence the repeated language about a personal relationship that, if denied, would demean the lives and claim of the individual, a relationship that causes a personal bond that is more enduring?
If you apply it that way, Your Honor, I claim that would then mean that before all the laws that have come along that have said that consensual adult sexual conduct that is voluntary and again consensual is permissible. We've gone
but that doesn't mean that it falls under Lawrence because then we've got our precedent, which was obviously preceded Lawrence, but IDK versus Clark County, in which we held that the relationship between a prostitute and a client, quote, possesses few, if any, of the aspects of an intimate association. And so if you read Lawrence to talk about the relationship and the intimate association.
But if you talk about the relationship, at what point in a relationship does one then have the right to make the decision to engage in the sexual conduct? Is it the fifth date, is it the sixth date, or the fourth date? What the court is ultimately saying, I believe that the intimate contact in the relationship is the two people engaging in the sexual conduct. That is an intimate act. And that, I think, is an intimate relationship that people have the choice to make. And if they make that choice and somebody puts a dollar amount to it, it should not alter the right of people to make this choice.
But that included in that group of people would be if, say, the hypothetical where the person chooses to have the quote-unquote intimate relationship serially, and so it's not the first, the second, or the fourth date or whatever. It's just a string of people that are engaging in prostitution. I'm not trying to, I'm just taking it hypothetically. I'm not trying to sound like the moral majority here, but
let's take away the idea that there's any pay for that. If people indiscriminately go from person to person to person, that's not a crime. And so that's a decision that they've made as to the personal activity that they want to participate in that intimate conduct. And I think that
then you're going to have to get into what the government's going to justify, that they're going to say that prostitution, as opposed to being just involved in a series of sexual liaisons, the thing with prostitution is they're going to say that's not a victimless crime because it involves sex trafficking, it involves pimps, it involves people using drugs and doing this and honestly, people that have done criminal law, which I've done a lot of in my day, that it's not, a lot of the relationships aren't really what you're describing if you go look, that they're people that are addicted to drugs that are out supporting their drug habit.
There are laws that deal with that. There are the sex trafficking laws. There's sexual exploitation that is a law. It has very serious penalties to it. There's non-consensual, where you drug somebody to participate in it. You don't have to take away the right of somebody, and I'm talking about people, my clients are people who have voluntarily, of their own free will, have decided and have chosen that this is a way that I can make a living. I'm perfectly happy with it. It is my choice, and I want to do this. I'm not talking about the exploited. That's why I'm saying this case is not about the person who has the pimp, who drugs them, who beats them and does all these terrible things. It's not the serial rapist. The serial rapist is still out there. He can still do it. He can find people that will consensually without any money because he's not really interested in that.
But we have to, but to reach your group of people that you're describing, we have to strike down the statute, right?
That's correct.
And you also agree that there are no allegations in your complaint that any of your clients or the people who want to traffic with your clients have any of the personal relationships or enduring bonds which Lawrence mentions?
I think I agree. They do not. They have at least at the momentary moment that they meet and they greet and they introduce themselves and they decide to go to it. They ultimately then at that point reach a personal, intimate relationship.
But I think your case would include an intimate relationship, as an intimate relationship, totally anonymous sex, masked sex of the type we saw in the movie Eyes Wide Shut.
Or Happy Hooker. But I mean,
so they wouldn't even know who they were.
Okay,
they wouldn't have any exchange of names. They wouldn't have an ability to recognize the persons conducting the sex by their face, and that they would still have a right to a constitutional fundamental right, substantive due process, based under Glucksberg, under the history of the United States, to do this.
Oh, it's not the history of the United States. At one point, I mean, seriously, we had brothels and we had prostitution. They didn't go at the conduct of the sexual act. They went at some of the conduct that may have led to it, like vagrancy or disorderly conduct, or what was displayed in a public arena.
So your answer would be yes. Yeah. Anonymous sex is a constitutional substantive due process right.
I stand here and say to this court that I believe there is a liberty interest to make that people have the right to make that choice. The only reason to prohibit it is really to base it on morality. And I think that when you look at it and you take it and you strip it away from the issue of morality, I think that people have the right in this country, under our Constitution, to act this way and to make a living this way. I believe the substantive due process and the right to make freedom of choice under liberty is a protected interest, in engaging in sexual activity is a liberty interest that I have.
I know what you believe. My question is, give me a case that said that.
Well, liberty interests go piece by piece, and I think we're at this point in our society and our development that we can recognize that.
What is it?
All the things that have been mentioned in rational basis about protecting women and about spreading disease and deterring all that can happen. Those same activities can still happen of women being raped in marital relationships. They can also be in a marital relationship where they're drugged, and all that can occur the same way, and there could be the spread of sexually transmitted diseases. And the only way to prevent all that is to just simply say that people are not allowed to engage in this activity, and you won't have any problem or worry about that. So I submit to the court that I believe that this matter should be reviewed under heightened scrutiny and not rational basis. Thank
you. Was there any evidence that this was not just a one-night stand?
There is no evidence.
Do you think that California can prohibit one-night stands?
No, I don't.
Why?
Well, California doesn't have any law prohibiting one-night stands.
But that wasn't the question. If they had a statute prohibiting one-night stands, would that violate the substantive due process of consenting adults?
I think that that would certainly present a closer question, but the Supreme Court and Ninth Circuit jurisprudence is that, at least in concept, what is protected is personal bonds of which sex can be a part. What differentiates prostitution is it's essentially a commercial transaction.
Let me ask you a question that was asked in the reply brief. Why should it be illegal to sell something that is legal to give away?
It's because the legislature can make a choice. The legislature can say, you can't purchase sex because of all of the attendant evils that arise in the context of prostitution.